10 seconds, 5 seconds, start. Be it noted, the DRAT, while its order, transferred the case to another debt recovery tribunal. As the property was sold in auction, the auction purchaser, the third respondent herein, filed an application for impleadment which was allowed. Before the DRT here stand was that she had deposited the entire amount of rupees 25 lakhs with the bank, and if the borrower was still interested to retain his property, he had to purchase it from her. The DRT, by its order, adverted to the facts, exertions made in the application filed by the borrower, reply filed by the bank, and appreciating the evidence on record, came to hold that there was no infirmity in the statement of accounts of the bank, and thereafter, taking into consideration the facts and circumstances, granted 15 days time to the borrower to pay the entire amount to the bank and the developer, Milestone Unitech, and rupees 1 lakh as compensation to the auction purchaser. Thereafter, the DRT directed as in case the applicant or appellant fails to deposit this amount within 15 days, the appeal or application be treated as dismissed, and respondent number 1 is free to confirm the sale in favor of the auction purchaser. Now, from the aforesaid pronouncement of law, it is vivid that an amended rule cannot affect the light of a candidate who has qualified as per the terms stipulated in the advertisement and is entitled to claim a selection in accordance with the rules as they existed on the date of the advertisement, that the selection can be regulated by stipulating a provision in the rule or laying a postulate in the advertisement for obtaining minimum marks are not prescribed for viva voce before the commencement of the selection process. The authority during the selection process or after the selection process cannot add an additional qualification that the candidate should also secure minimum marks in the interview, that the norms or rules as existing on the date when the process of selection begins will control such selection, and that revisiting the merit list by adopting a minimum percentage of marks for interview is impermissible. The factual scenario in the present case has a different backdrop. The advertisement stipulated that the shortlisted candidates would be called for interview before the final selection, and mere fulfilling of minimum qualification by itself would be entitle any applicant for being called for interview. Thereafter, in the instruction, the marks were divided. Regard being had to the level of the post and the technical legal aspects which are required to be dealt with, a concise decision was taken to fix 65% marks for OBC category in toto, that is marks obtained in the written examinations and marks secured in the interview. It is not a situation where securing a minimum marks was introduced which was not stipulated in the advertisement. A standard was fixed for the purpose of selection. Instant is not a case where no minimum marks prescribed for viva voce, and this is sought to be done after the written test.